My lady, recordable offences.
Ah,
The regulation in question is in Authorities Bundle 4, tab 46, MS 1479. And the 1997 Act links to the regulations because the CCRC or ECRC gives details of every relevant matter recorded in central records, 113 capital A sub 3 sub little a, and central records is defined at 113A sub 6 as records of convictions and cautions held for the use of police forces generally or as may be prescribed. So that's the
link. Yes.
And what I was struggling for was G's conviction and Schedule 15 and the relevant paragraphs of those. I think the answer to that is his conviction was under Section 13 of the Sexual Offences Act 2003 in conjunction with Section 9 of that Act, and they appear at paragraphs 110 and 114 of Schedule 15. So I hope that's helpful. I was making some general submissions on application before coming to the specific features of the scheme that are the subject of critical debate before you. And the third submission I make is that the 1997 Act as amended does not require the indiscriminate disclosure of data it has collected and stored. That was the way in which the vice of the previous legislation was described by Lord Reid in T. So we still have that open in volume 3, tab 21, and the relevant passage for this purpose is 113. And you'll see the final sentence of 113. Put shortly, said Lord Reid, legislation which requires the indiscriminate disclosure by the state of personal data which it's collected and stored does not contain adequate safeguards against arbitrary interferences with Article 8 rights. But that was the essential vice that he identified, and the legislative changes very deliberately move away from that position of indiscriminacy, if properly so described. And they do so as a result of the Court of Appeal's concern in T and the work of the expert panel and Miss Mason and everyone else to consider and devise precisely more nuanced solutions. And as I submitted in opening the new regime, it distinguishes on precisely the sorts of bases whose absence was cumulatively the vice in T. You can no doubt say it doesn't go far enough in relation to some of them, but it distinguishes on the basis of type of offending, disposal of offence, length of time since offence, age of the offender, and all of that. So a series of interconnected rules. And all of that we respectfully submit against the backdrop, albeit in a different context, of, for example, convictions alone being enough of a differentiation in Gochran, and automatic features, I think serving 3 years or more, being enough in the context, for example, of prisoner voting in Scopula. So whatever else may be said against me, as I said earlier, the stick that was used to beat me last time round in T is no longer available. Maybe a different stick, as was pointed out very helpfully by my Lord Kerr, but that particular stick is gone.
Cast about for one, Mr. James.
Paragraph 48, the stick in question, the previous stick at least, was that Ms. Mason and the instruction to her from the Secretary, as he records in para 48, I think, of his judgment, was to scale back the criminal record system to, quote, common sense levels.
So reading the evidence, Ms. Folds' evidence, which I did over lunch, I mean, there's a fundamental issue of approach, isn't there? Because basically what the sort of Sunita Mason has her group and tries to come up with a scheme. and she finds that there's, not surprisingly, a lot of different views about what a serious or non-serious offence is. And faced with that, the government seems to take what they call a cautious approach, which errs in favour, or at least tends in favour of disclosure on the basis that the employers presumably can be trusted to know something which is really not serious. I mean, it puts a lot of weight on what the employers do rather than what the government's doing. And there's really a sort of fairly fundamental issue here, is whether that's a proper approach, really. And we'll see how you put it, we'll see how the others put it, but there's really a point of principle there.
Well, Lord, I think there is, and I'm going to come back to it because it's one of the essential points that's being made against me. I mean, to some extent, that question collapses into the question whether you need some form of individualised scheme, or can you set it up in that way with the broad structures involved? And of course, it does require the employers ultimately to bear some weight, but we've now got the intermediate stage. In the old days, when it was before T, it was all convictions or cautions and an enormous amount of weight on the employers. Now we have quite a lot of nuanced lines, structural, bright, whatever you want to call them, and the consequence of those, as we saw from that table I took you to at 6011 in the core volume, the sideways table, is that a third have actually been filtered out and so go nowhere near the employers. But my Lord is right. The question ultimately, or a question of real importance in this context, is whether Parliament is entitled to set it up in that format, or whether you need, through individualised decision-making or some form of review, which you then have to design, something rather more. That, to some extent, is the significance of my submission emphasising the word cumulatively, both in MM and in the judgment of Lord Reid, because one part of that list was, in effect, independent review. And the question, therefore, is whether you can do the other bits in there and distinguish on structural lines without doing the final bit, because we don't. So, my Lord, I agree with that characterisation of at least one of the major issues. But my point at the moment is that unlike T, you have now got distinctions being drawn on that structural basis on all of the ways that I identified at the outset, and that does stand in quite stark contrast with Gawker and Scopola and all that line of cases. Fourth general submission is that the elements of the revised scheme necessarily, and the point my Lord has just drawn my attention to about that basic structural difference is perhaps one of them, but the elements of the revised scheme do involve judgments and balances, as of course the headline judgment and balance about precisely, which Sunita Mason referred to, as you'll recall, about precisely where you balance individual rights against the protective aims of the scheme. Do you cut out too much? Do you cut out too little? Do you need an independent review or something individualised? Are the serious list of offences, if that's an acceptable way of at least doing part of it, as plainly they are, you include just murder, then you've got to make a judgment about where in the list of offences do you draw the line, if that's a structural line. So all of those involve judgments and ultimately balances, and we respectfully submit that there isn't a single answer to those, and that to some extent founded the submissions I made about the difficulties of seeking, as it were, to pigeonhole it with no margin consequence in one place rather than another place, when essentially you're asking the same question. Is this scheme within the margin that the Strasbourg authorities and the Convention allows to the legislature? And it is entirely clear, not least from T and its outcome itself, that the submissions that I make do not leave Parliament with a carte blanche. What they do is to ask questions about the reasonableness or the adequacy of the scheme, and the question is one of approach as to how you should go about doing that. And I'm not going to keep banging the drum. You know my submission on that. Fifth point of a general nature is that this set of changes is not window dressing. It has self-evidently tilted the scheme against disclosure. We know that because if you look at the sideways table, a third of things which would have been disclosed under the T scheme are no longer disclosed, and that means they get nowhere near the employer. I don't know whether that's a good thing, a bad thing, or an indifferent thing, but if you've altered it so that a third no longer go to the employer, there is at least the possibility that it's tilted it too far that way, because some bits of information which might otherwise be considered to be relevant are no longer going on an automatic basis. But that, for good or ill, is the judgment that Parliament has made, and it has had a really pretty significant effect in terms of filtering out of a third of what used under the T scheme to be provided to the employer. And it's done so on an automatic basis, no longer going to the employer at all, and that leaves, as it were, the remaining two-thirds with the employer making the judgment about relevance and significance and so on. So my overall submission in general terms, before coming to the specific elements of the scheme, is that the scheme is, to use the words in Christian Institute at paragraph 88, Authorities 6, tab 59, MS 2043, capable of being operated in a manner which is not incompatible with convention rights. And on that basis, the court should, I respectfully submit, be slow to interfere for that reason, and slow to interfere also for the very reason that Lord Wilson gave when he came to analyse the matter under the old scheme in relation to necessity, where he said in relation to the necessity of the old scheme that there were potentially issues of fine judgment which, by affirmatively approving the 75 order and by enacting the 97 Act, Parliament itself determined that the court should therefore hesitate long before concluding that its judgment in these respects was wrong. And that he described as a valid preliminary point that had been made in that case, obviously in the context of even of a scheme as general as it used to be. So those are the general submissions I make. Can I turn to the specific features and start with the list of offences? The list of offences is obviously relevant particularly to the G case and to the W case. And the Court of Appeal characterised the scheme as indiscriminate because it differentiates only by reference to seriousness. That was paragraph 45, and we respectfully fundamentally disagree with that conclusion. The majority in T did not require differentiation by reference to particular factors. And indeed, the Court of Appeal themselves accepted that a rule which always disclosed, for example, a conviction for murder in the form of review or anything else, could not be challenged. They so accepted at para 40 of their judgment. And that was stated because there was, in that example, a clear link. We're back to the discussion I had with Lord Sumption about capable of being relevant, but there was in that situation a clear link between offending of such seriousness whenever committed and the need to have regard to the interests of public protection. But once, in principle, it's acceptable to have a list of serious offences, you know where this is going, and plainly it is, murder, rape, offences against children and so on. Thereafter, it is ultimately just a question of judgment as to where you stop that and what additional elements feature.
The odd thing about it is that they borrowed the schedule from the Criminal Justice Act 2003, which certainly did set out, didn't it, to list offences of the kind which might give rise to a future risk of serious dangerousness, as the Act called it.
Yeah.
But it did it not simply by reference to the gravity of the offence. Oddly enough, very large-scale drug smuggling, for example, isn't in the schedule at all. It did it by reference to not just to the list of offences, but to a risk of serious harm, which is described as death or really serious personal injury. I think someone will correct me if I'm wrong, but I think that's it. Through the further future commission of some of these offences. In other words, all that it is saying is that they are offences which might, if committed in the future, be the kind that bring with them a risk of death or very serious personal injury. It isn't actually necessarily saying that every instance of each of these offences is necessarily particularly grave.
No.
Maybe that it was a convenient,
Proxy.
as you say, proxy, but it isn't intended to be a list of the more serious offences in the
No,
criminal calendar.
and my lord, we were looking over the short adjournment to see the drugs offence example.
Well,
It was
right.
it is a good one. So it is a proxy, and it may not be perfect,
But you say it's the best they can do.
but I say
they were trying hard.
it's an acceptable thing. When you put it alongside also, you'll remember how 6D was structured.
Yes.
So that it then contained, it's in effect in two parts, as it were, or rather more than that, but there's a Schedule 15 bit, and then there are the bits that are specifically directed to suitability and vulnerable people and so on. So, I mean, I'm sure the offence list could have been done in a slightly different way. It may be flaky at the edges, as it were, but the basic intent, and that it can be kept under review, but the basic intent is to seek to drag in, if only by proxy, those things. And the reason I emphasise the second category is because I think it may not cover the precise example that my lord had in mind, but at least some of those other offences may well drag in drugs elements through them, if that makes sense. So, but whether that is precisely in the right place or not, whether that is a legitimate proxy or not, I mean, those are judgments you'll have to make your mind up on. But I respectfully submit that a list which is essentially directed at seriousness, coupled with a list of the more specifically targeted offences, is an acceptable legislative way of trying to do this. And the rule is beneficial on the basis of the offences, I respectfully submit. There is a rational connection at a systemic level between the seriousness of the offence as a type of offence and the purpose served by disclosure. Of course, it leaves some element of judgment on the fringes to the employer. But we're back to that. It doesn't have to be demonstrated in this sort of scheme to avoid the charge of indiscriminacy of the structure, that every offence will always be relevant in every case. The system is set up in a different way in this disclosure regime. So that's how the list of offences works. There is then it's then said against me, well, there isn't any consideration of disposal built into the scheme. But that, it might be thought, is part of an insistence, if there is one, on specific decision-making, individualised decision-making. So you can't actually decide, is the punchline of disposal. You can't actually decide unless you see precisely what offence drew what a particular disposal in that particular case. And then you have to know a great deal about the individual case. And it ceases to be a practical, functioning and efficient system, in our case based on automated lines because of the numbers, but it just ceases to be such. The scheme does, of course, draw lines on the basis of disposal, if custodial, always disclosed. You'll remember that bit in the in 113A6. And if a caution, excluded from the two convictions rule. And so the question is whether one needs more in relation to disposals built into the scheme to avoid the charge of it being indiscriminate. And I respectfully submit not. It's just a question of judgment as to how you set up that set of structures. And this was an issue which Mr. Justice Simon considered in a little detail in the case that he was dealing with. Can I just invite you to turn up briefly one paragraph in that judgment? It's in Authorities Volume 2. At tab 8, MS 491, and we want paragraph 70. So he considers this sort of issue, but it may be thought that even beyond the points that are made in that paragraph, there is a more general question about the extent to which you can or should or need to get involved with the precise individual circumstances of precise cases. I mean, we know jolly well that in the criminal context. Every disposal is thought about very carefully, individual circumstances taken into account, pleas in mitigation more or less persuasive, and all the rest of it. But that is, in essence, if you're arguing for that as a necessary precursor to avoiding the charge of indiscriminacy, you need, and you have to argue for an individualized scheme, and that carries all sorts of difficulties. So that's what we say about the list of offences and disposal. The multiple convictions rule, the 2 or more convictions rule, that benefited, that change alone benefited, you may say it doesn't go far enough, but it benefited a very large number of people. Can I just invite you and put volume 2 away? If you take up volume 2E again, in the appendix, and just go to folds 2, again, I'm not going to trace it through in any great detail, but folds 2, this is 1536 in the hard copy, 7659 in the electronic. And I think I referred to these paragraphs earlier on. Do you remember there were the paragraphs dealing with the percentage of the population with a conviction, which was quite a startling percentage. But the punchline, really, for present purposes, is in para 28, where, having analysed the figures, he concludes that a really quite significant proportion is in single conviction territory. And so, again, there are quite... one can assume that this change also will have significant effects and represents a significant filter. So it benefits a significant number of people, this change. It is obviously a nuancing on the scheme. It applies only to convictions, as I pointed out earlier, and it applies only if there's more than one. Ms. Mason, you will recall, I'm not going to go back to it, it was MS 7621 or 1498 in the in Appendix 2E. Ms. Mason positively, I think 2D that should be, Ms. Mason positively recommended it be set on this basis. Do you remember, set the number at 1? And did so, we respectfully submit, on the basis that this is at least a perfectly legitimate indicator of concern, and also, as she pointed out, because a precautionary basis was appropriate. Entirely appropriate, we submit, given the consequences and the interests at stake. True it is that part of the focus of this is on the propensity to demonstrate a pattern of offending, and if you have, as it were, 2 offences all committed on the same day, then it may be that it's not a terribly useful yardstick for that purpose. But in essence, what the legislature is evidently doing with this 2 conviction rule is to search for a workable structural rule within an automated system. Folds 2, para 23. And on that basis, 2 offences are pretty obviously of more interest than 1 in the run of cases, in the majority of the cases. It could indicate or demonstrate a pattern of offending and may well do so in a significant number of cases. It may not do so in all cases or in every circumstance. But the question then is, well, how do you then set it up structurally otherwise? Considered and rejected, as you will recall, see folds 2, para 21, was designing some sort of element of the system that would enable you to treat, in effect, 2 offences as one lot of offending. And everyone just thought, well, that's just impossible to do. It's too difficult to set it up on that basis. You can't create these sort of structures in that way. And how should it be done? If it isn't done by number, how should it be done? And if it is done by number, is it 2? Is it 3? Is it 1 offence followed by a break of 6 months and then another offence? I mean, there are no doubt a variety of ways in which one could do it differently. But I respectfully submit it isn't unreasonable to treat multiple convictions differently to single convictions, and it isn't illegitimate to devise a simple numerical conviction basis for a scheme of this kind, with the numbers flowing through it and its automated base and all the rest of it. It certainly isn't indiscriminate and can't properly be characterised as such. What then about the timing and the period since offending? Again, I think the big answer in relation to that part of the scheme, how long since the offending, is that the scheme is indeed set up to take account of that fact, but it does so in relation to the default rules and the default definitions of currency, which, as you recall, do have that time from offending built into them, both in relation to convictions and in relation to cautions, although, of course, it applies differently with different periods, reflecting the fact that cautions are likely to be less serious than convictions. But that scheme is subject to express exceptions, that basic default rule, and those exceptions, as we saw, are the multiple conviction rule and the seriousness of offence rule. And again, one can perfectly intelligibly understand and reasonably understand that as a structure. You say, well, in ordinary circumstances, we're going to move from a position where it was all offences however long ago, or all cautions however long ago, to a system where you've now got a long stop in terms of time and age of offender. But we're going to cut out from that those two elements, serious offence and multiple conviction. And so we come to the nub of it, it may be thought, coming back to my Lord Carnwath's question, which is whether or not the Act should set up and needs to set up individualised review or some form of independent review. And my submission is that it doesn't have to in principle, because the distinctions already drawn by the legislation are sufficient when the scheme is viewed in its totality to avoid a proper characterisation as indiscriminate or blanket. And the Court of Appeal, I may say, at least agreed in principle with that position. See para 40. They kept returning to it as a vice of individual cases, but they did agree in principle, para 40, that you don't need an individualised scheme, and they were right to do so. It's dealt with in some detail in the evidence. And again, I don't invite you to go back to it now, but particularly Folds 1, para 37, MS 7397, and Folds 2, sorry, hard copy there, 1274, and Folds 2, para 41, Appendix 2E, 1542, and the hard 7665 in the electronic. And a statement we haven't yet looked at, but again, maybe worth a bit of a look, is, or I think we looked at it for a different purpose, which is a statement of Mr. Ray, Samuel Ray, which is in Appendix 2E, and the relevant paragraphs are 23 and following, 1587 in the hard, 7710 in the electronic, setting out why it was that there would be real difficulties on if you set it up on an individualised basis, and setting out the difficulties with relevance and all of that.
1507, did you say?
1587.
Oh, beg your pardon.
I think it should be Ray 23 and following on the difficulties of the
Thank you.
relevance test. Just in terms of the case law on this, can I start with individualised, because there's obviously a potential difference between a scheme that requires every individual case to be considered prior to disclosure, that's what I mean by individualised, and a rather more nuanced scheme which has independent review with more or less stringent preconditions before you get into it. But on individualised, I start with this because one needs to be a little cautious, I respectfully submit, with some of the phraseology used to summarise the principles in different contexts. So in Christian Institute at paragraph 80, Authority 6, tab 59, 2041, the court identified, quote, safeguards which have the effect of enabling the proportionality of the interference to be adequately examined. And you'll remember that sort of language in the judgment of Lord Reed in the T case. But one needs to be a little careful with that, I respectfully submit, because there isn't any support in the European Court of Human Rights case law that it is necessary in a context like this or more generally for there to be an individualized scheme or a review in all cases. And indeed, any acceptance of a principle of that generality would directly cut across and be inconsistent with an acceptance that it is legitimate to set up bright line rules, despite the existence of hard cases on the margin. So it would be a very big submission, and indeed would be inconsistent with a whole raft of cases, including Lord Wilson in Matheson and all those cases I cited earlier on about bright lines, but also inconsistent in the result with a case like Gochran, where there was sufficient nuancing in the scheme because of the introduction of the bright line or structural rule that said you can now retain DNA or biometric data solely on the basis that you were convicted. And that is the right way of examining this, and indeed the references to review more generally, is, we respectfully submit, again reinforced rather than undermined by Lord Reed's judgment in T, where he goes out of his way to produce the list of cases, the list of factors to be taken into account and that the scheme didn't then differentiate on the basis of, and then said cumulatively. So he wasn't setting it up on the basis that individualised consideration was required. If that had been a requirement of the convention, the T judgment could have been a paragraph long, because no one was submitting that individualised consideration formed any part of it in that sense. In context, of course, it would make the scheme almost entirely unworkable, because you would have, and I can't remember what the numbers were in the sideways table, but 330,000 odd in England and Wales matching PNC records, 200 odd thousand after filtering under the new rules. And so individualised consideration in those cases would be a very, very significant undertaking. And we would urge, without going back to it, I'll see how my learned friend Mr. Southey develops it, but we would urge considerable caution with some of his references and footnoted references to numbers and percentages in relation to ECRCs, and how often it is that police truly, even under the ECRC regime, need to engage in individualised decision-making. The position as we understand it, at least in relation to the numbers in the evidence that we have in the files before you, is that, to take one example, Mr. Ray again, Appendix 2E, 1587 in the hard, 7710 in the electronic arrow 21, says that in 2014 and 15, roughly 10,000 of the over 4 million ECRCs issued contained soft intelligence included by the chief officer. And I think you have equivalent numbers in the Secretary of State's case before this court in AR for 2015 and 2016, or the financial years 15-16 and 16-17.
That's the number that where it's
included,
where it's got in.
I was about to make that point. That's the number where it's got in. We don't quite know, I think, and we were seeing at lunchtime whether we had any better statistics for how many were actually considered leading to that, and we'll see if we can assist you on that, because that would be the...
I think we were told in an ECRC case, which we had, that although in theory the decision falls to a chief officer, it's usually delegated, but I think to an inspector or above or something like that. Is that right?
Yes, I think it is. Again, we'll
someone
check
check
to make sure. But anyway, we're talking on this primary way of putting it, individualised decision-making. We're talking with a very, very large number of cases, wholly impractical to have a scheme set up in this way at all, if that's truly the requirement. But there's nothing in the Strasbourg case law or the domestic case law to suggest that is so. And then I come to independent review of decisions, which is obviously the lesser alternative. And that certainly was one of the matters referred to repeatedly by the Court of Appeal in the PG and W cases below, and referred to in the list of factors by Lord Reid at 119, as you will recall. But we respectfully submit that referred to because it might have been thought to be a necessary antidote in circumstances where the regime did not otherwise, as it didn't in T at that stage, differentiate or distinguished on the nuanced structural basis we have now. And there is all the difference in the world, I respectfully submit, between references to independent review as one of a cumulative list of factors and saying, well, that is a mandatory requirement. And again, I make the same, it might be a rather glib point, but if truly independent review was a necessary feature, a sine qua non of compatibility of this sort of scheme, then the judgment in T would have said so.
You want to say anything about the suggested analogy with the sex offenders notification system?
Well, I'm going to come to the other comparisons. We respectfully submit that that's not an apt comparison.
Okay, well, do it in your own time.
No doubt one could get the numbers down. One could invent more or less stringent conditions for review based on time or offence or age when convicted and so on. No doubt one could try and do that, but of course the difficulty that always arises then is the moment you set them up, the next challenge that comes along says those are too stringent as conditions for getting into the reviewing scheme, as indeed I think has occurred in Scotland immediately, and then you have everyone. And the idea that then occurs is, oh well, surely only people who really thought they had a good chance of doing it would access the scheme, and therefore the scheme would have to be set up to take only a smaller number than the very, very large numbers of people who are, to whom if it was open to all would be have to be catered for. But the difficulty with that is that one has in the bundles at least some examples of cases where people have challenged, even on the basis of pretty serious offences committed pretty recently. I think there's a decision of Mr. Justice Knowles which has been referred to, called HA, where the individual concerned was applying for a sensitive post aged, I think, 19 and committed 2 offences of robbery aged 15 and another offence, so was within almost every one of the rules under the new scheme, currency, serious offence and multiple offending, and was nevertheless challenging and could be expected to challenge through a review if a review was available. So it may be jolly difficult to set up a reviewing system with sensible preconditions that would enable the numbers to come down. So one is actually talking about a pretty large pool. And in our set of circumstances, it's, I suspect going back to that table again, it's the 200 to 250,000 number of those ECRCs which survive post-automatic filter. Those would be the ones that the scheme would have to cater for. And so my first submission in relation to independent review is that it isn't necessary, and Lord Reid didn't say it was, see cumulatively. Second, you can't assume that the numbers are going to be manageable. It's a very, very large thing, and that goes to the legitimacy of the parliamentary judgment not to introduce said scheme. Thirdly, and linked, considerable expense and administrative burdens inevitably associated with that sort of setup. It may well be possible to do so in jurisdictions where there is a considerably smaller number flowing through the system. But in the context of England and Wales, we have the numbers, and I respectfully submit you can't assume it's going to be anything less than those numbers. Fourthly, the system is set up so that judgments in the end now under the new scheme may have to be made by employers, but you only get to that point once the automated systems and the structural rules that Parliament has designed have worked their magic. And they are sufficiently nuanced in their own right, I respectfully submit, to amount to a non-indiscriminate scheme, but you only get to the end consideration by the employer after that. So the disbenefits of that sort of scheme are that you end up with a loss of speed, you end up with reviews taking a considerable amount of time, and of course that in itself is not neutral necessarily so far as the applicant is concerned. I mean, employers may well get to understand quite well how quickly or slowly these sorts of certificates are produced. And if a review is going to take 6 months or a year, you go ho-hum, coming any minute now. But that itself tends to reveal. So it's not necessarily without cost to applicants. It would have to be done every time, potentially every time the role changed. And of course, one sets up, depending on precisely how any such review scheme would be set up, you end up with the potential for inconsistency amongst decisions, which risk increases exponentially with the numbers of cases that would have to go through any review system of that kind. But my core submission on independent review is that it isn't an essential feature of this sort of scheme. And I recognise in making those submissions that, of course, alternatives are possible. Part of my argument on outside the margin is that it's perfectly legitimate for other Council of Europe countries and indeed for other parts of the United Kingdom to set up a scheme which looks different to the one that exists in England and Wales. You can't necessarily move from a position where you say, well, because Northern Ireland, for example, has some form of review scheme, you therefore must regard that as being possible and outside the range of judgments if you don't have it in the context of England and Wales. There are obvious differences of scale. So, for example, and again I'll leave Mr. Cole to deal with this, but there are obvious differences of scale. I mean, at the high level, if I've understood the figures correctly, just over 100,000 as compared with over 4 million on the basic ECRC numbers. And pretty small numbers going through that that reviewing system anyway. So far as the sex offenders register is concerned, I think my short points and answers to my Lord's invitation to address that, my short submissions are that the volumes are lower and they are subject to a much simpler review. That's probably a grotesque undersummary, but we've dealt with it in our case at 115, MS 5949, and it was the subject of specific treatment in the evidence. This is the sex offender register a comparable thing, and does it demonstrate that you could set it up in our context? And again, I don't want to take up time with it now, but to give you references, Mr. French gave evidence. I say gave evidence, he produced a statement, and that's the relevant passages in French are 7 to 15 and 19 to 20 on this specific issue about the comparability with the sex offenders register. That's in Appendix 2E, 1604 to 9 in the hard copy, 7727 to 32.
Sorry, just repeat that, please.
7727, my lord, sorry.
And the paragraphs again, please.
Paragraphs 7 to 15 and 19 to 20 in Mr. French's evidence. But there are, as we know, it's been helpful to have the exposition in all its complexity of the Scottish system, and Mr. Cole will address you about the Northern Irish system. We know that there are different...
Talking about differences of scale, population of England and Wales is approximately 40 times that of Northern Ireland. And you say 100,000 in Northern Ireland, apply 40 to that, it's about 4 million, isn't it?
So it's probably the same in terms of percentages, as it were.
Yeah.
Yeah, but the relevant figure, it might be thought, is how many you're actually going to have to cater for when and if, for example, the reviewing system is set up.
Yeah.
And
It
so
means, I think, to be a little careful about
one does have to be a little careful, of course.
statements about difference of scale.
Yeah, one does, but on any view, unless one can confidently say we can find a way of filtering out those cases that go into the review system, if you've got something like 200, 250,000, which the tables tend to suggest of those numbers post-filter, post the change, you've got a very significant administrative body with all the dramas that are associated with that. But we respectfully submit that it isn't necessarily a disbenefit, and one needs to be I entirely agree with my lord, extremely careful before reasoning from the existence of a particular nuance scheme in one jurisdiction, be it other Council of Europe or be it within the United Kingdom exercising devolved competence, before reasoning from there back into the position in England and Wales. So that's my answer to my Lord Hughes' question. I hope that's not too referencey. I was going to turn briefly to the individual offences in W and in G, slightly out of order, but maybe worth just making some brief submissions in relation to those. And you'll recall that in the W case, the offence was ABH, and so it was a serious listed offence. You'll recall that Mr. Justice Simon at first instance held, in the face of no challenge, as it were, to lawfulness, that it was proportionate for that to be included. We make our points about the nature of that offence and its inclusion in our case at paragraphs 83 and 106. The inclusion of ABH was a specific recommendation of Ms. Mason that offences of violence against the person be disclosed. I think she originally recommended even including common assault. But Parliament then adopted a line more generous, as it were, to those who were convicted and plumped for ABH and not common assault. I think that's the way the history developed. And we respectfully do not accept, for all the reasons I've given, in this context, and for the reasons summarised by Mr. Justice Simon at para 70, to which I've already referred you, that disposal truly assists. It isn't workable, we respectfully submit, to adopt a rule by reference to whether or not there was a conditional discharge. And the reasons for that are analysed in Miss Fold's first statement at paras 42 to 43. W, in his case, queries the designation of ABH as a serious offence, given that the provisions of the Criminal Justice Act designated it only as a specified offence. But I respectfully submit that that's a pretty barren debate, and it's a pretty barren debate, I suspect, for the reasons that will be evident from the discussion that I had with Lord Hughes a moment ago, which is that this is a proxy. And the real question is whether it is illegitimate for Parliament to have decided that the offence of ABH but not of common assault represented the boundary for the purpose of these regimes. It cannot be said that an offence of assault of that kind isn't capable of being relevant to the safeguarding issues which this scheme is designed to protect. And so the complexities of how it ultimately came to be in that schedule and how it precisely works in terms of a distinction in that legislation for that purpose between serious and specified offence is, we respectfully submit, neither here nor there. The essence of W's written case is that his case is a hard one. But I respectfully submit that that isn't, in truth, any more than an expression of the fact that the relevant legislative regime is set up on the basis of the structural lines that I've indicated. It's of the essence of bright line legislation that there will be difficult cases on the edges. Whether you choose to characterise his case as a particularly difficult one is a purely factual issue. So far as G is concerned, G was convicted of a sexual offence. I say convicted, was reprimanded for a sexual offence of the kind that I gave you the reference to earlier on. And he accepts entirely fairly and properly that the offence on the face of it was, he put it, extremely serious. But he says that extremely serious offence was committed when the individual was a child and was criminal only because all children were involved, so couldn't legally consent, and so it isn't as serious after all when one looks at the individual circumstances. But I respectfully submit in answer to that if you're looking at the structural regime, sexual offending involving children, even if you are a child yourself, lies pretty close to the core of what any disclosure regime would be expected to disclose, having regard to the safeguarding interests at the heart of it. So far as that is concerned, therefore, we make our submissions on the nature of the offence in our case at paragraphs 82 and 106. Childhood criminal records were indeed considered, contrary to what is said in G's case at paragraph 24. Juvenile offending provided, for example, I'm just going to give you the references if I may, 2 of the 5 examples at paragraph 93 of Ms Mason's March 2010 report, MS 7422 or 1299 in the hard copy. That subject matter was also the subject of Rule 3 at paragraph 97 of her second report. And you'll recall in the last little passage I invited you to read from that about Guildford HE at MS 7481 and 1358, that was also about children and child offending. Her final report indicated, the December 2011 one, indicated that extra consideration, particular consideration, should be given to youth records and different filtering set up for under 18 offending. Mason final report, December 2011, Appendix 2E, 1498 in the hard, 7621 in the electronic. And that is indeed what happened, and Parliament set up the scheme. It set up the scheme to make special provision for children. And the whole regime does that. So Table A to Section 5 of the 1974 Act shows that there are shorter rehabilitation periods for child convictions already. So even at that base level, there's a distinction on that ground. Authorities 1, Tab 3, MS 244. Standard and enhanced checks are only available to those over 16. See Section 113A 1B of the 1997 Act, Authorities 2.
That's at the time of the request for the certificate, is it?
That's at the time of the request, I think. I'll double check that, but I think so. And as importantly, or perhaps most importantly, a reprimand for a non-specified offence will be filtered out in accordance with the rules set out in 113. There are, we respectfully submit, and again, contrary to the case advanced by G, no international law obligations, still less international law obligations that are binding in domestic law in this context, prohibiting disclosure relating to children or to those who were children when they committed the offence. The Beijing rules on which reliance is placed are not binding on member states. They're in Authorities 13, tab 130, if you want them. And see, in that respect, my Lady Hale's judgment in R against Durham Constabulary, if you recall that one. A2, Authorities 2, tab 19, 794 at paragraph 26 in particular. So the Beijing rules don't advance the case. Recommendation R8720, Authorities 13, tab 126, on which she places reliance, MS 4730, positively envisages at paragraph 10 the use of childhood records on compelling grounds provided by national law. Article 14.4 of the ICCPR, Authorities 13, tab 128, MS 4740, that is concerned with the treatment of juveniles within criminal proceedings and is a taking account obligation. As is Article 40 of the UNCRC, also a taking account obligation, and Article 3 of the UNCRC requires a balancing of the rights of G, who is no longer a child, and other children who are children now, and various balances need to be struck under that provision. So we respectfully submit that the international law reliance is not is not of assistance. My Lord, 113A is the answer to my Lord Hughes' question, age 16 or over at the time of making the application. 113A brackets 2 little a's. So I can't believe they got to the end of the alphabet and come back again, but they had. So that's what we respectfully submit in relation to children and the way in which children are dealt with. The core and essential point, it might be thought, being that the scheme already differentiates for those who are under 18 at an earlier level, but in the particular part of the scheme that we're now looking at, the default rule, the basic rule from which exceptions, it is true, are cut out, and those exceptions apply in the case of Mr. Owen's client here. But the basic and default rule is that there are specific rules which positively take account of the position of children by making the basic currency provision shorter in their cases. That leaves me only, I think, by way of opening, with the cross appeal, and I'm not going to take up any real time on that at the moment. It's for Mr. Southey to make the running on that. But the short point in relation to that, or the short points in relation to that, are dealt with in our, I hope, suitably crisp case on the cross appeal, which is in tab 11 of the core bundle. And I think there are only about 4 or 5 pages of short points on the cross appeal. The essential dispute in relation to the cross appeal is, of course, whether the whole of the 1975 order needs to be quashed in the event of Southey victory, or only the multiple conviction rule, and we respectfully submit that there is a host of authority, including T itself, which makes it absolutely clear that under the remedial discretion which is afforded in those circumstances, the court should only deal with and address remedy towards those particular features of the legislative scheme that are offensive. You'll recall that the big difference between Court of Appeal and Supreme Court in T was that the Court of Appeal I think they'd quashed the whole of the 75 order, and the Supreme Court disagreed and said, no, we're only after the target which we found to be incompatible, and that is entirely consistent, I think, with my Lady Hale's approach in Tijeri, to take another example, but that targeted approach to remedies, we respectfully submit the correct one. So that's all I wanted to say orally in relation to that question of remedy.
How are you doing this?
I was just pausing to see whether I could entirely stop there or whether I ought to put down a marker. And the only marker I was hesitating over was, you'll remember in T, there was a debate about whether or not the 1975 order raised different in accordance with law issues to the 1997 Act. Essentially because the 1997 Act was directed very much at state action in terms of issuing the certificate, whereas the 1975 order was rather closer to kind of positive obligation territory, where you were regulating relations between private individuals inter se. And we've made, I just want to put down that marker, we've made some submissions about that in some detail. I suspect that they're not immensely close to the heart of this appeal, but lest it be forgotten, our case at paragraphs 85 to 93 deal with that tight and interesting issue. Those are my submissions.
Thank you very much indeed, Sir James. Thank you. Ms. Gallagher?
My lady, my lords, I'm very grateful to my learned friend Sir James for the submissions that he has made. The court will not be surprised to hear that I adopt those and will earnestly try to avoid repetition of any of the points therein. And no doubt if I fail in that
I'm sure my lords will tell you if
I
you're
was
not
just about to say, I've no doubt I will be very quickly Sorry, I'm just being adjusted, hopefully appropriately. So, as I'm saying, I'm sure if I do move into repetition, I will be stopped in my tracks. Can I first of all perhaps just indicate that obviously in the Gallagher case, the main aspect is the multiple conviction rule, and you've heard detailed submissions from Sir James in relation to that in one of the English cases already today. And there's a clear interaction between our case and that English case. It might be useful just to look, in setting the tone for the Northern Ireland situation, to some of the statistics that apply in the Northern Ireland scenario somewhat differently from the English scenario. So if I could ask you to turn in the core bundle in relation to Gallagher to MS 8135, hopefully. The court will see a short table set out at paragraph 94 of our submissions in that regard, and divided the two types of certificates chiefly in play in this regard, standard and enhanced, as they are known in Northern Ireland. Obviously the enhanced being that which includes soft police information and also any information relating to entry on a barring list. And you can see from that the number of certificates reviewed, that is those with information. So whenever the system receives an application as a matter of automation, it will determine, first of all, whether in fact there is any criminal record information known in relation to that applicant. And that will be the figures that you see there in that first box. First two boxes on the left-hand side. I'm told that's somewhere in the region, in enhanced terms, of around about 6% of the applications that are received have information. And in relation to standard, somewhere in the region of 16%. So those are the figures that you're seeing as and when information is seen on the scheme. Moving across then, we see that whenever the filtering rules as apply in Northern Ireland from April 2014 are applied, that in relation to standard certificates, approximately 20% have filtered information removed, and just under a quarter of the enhanced certificates have information removed. Now, in the context of the multiple conviction test, we say that the mere fact of multiple convictions is a relevant factor. It is clearly a different state of affairs from the situation that pertains in relation to an individual who has a sole conviction. We say it is potentially significant as an indicator of potential propensity or recklessness as to the requirements to comply with the criminal law, and that has a particular resonance in the given context that we are operating in the context of these cases of risk management, protection of the public from risk. Constructing the scheme that applies in Northern Ireland in such a fashion so that this information will be subject to disclosure is, we respectfully say, an exercise of a balanced and rational judgment on the part of the Department and the Legislature. It is, in that context, an important factor or category of information to be made available to employers. And when we look to some of the specific situations, or specific facts, I should say, relating to Mrs. Gallagher's case, we can see that not only as a matter of generality, but also as a specific in this case. So, looking to Mrs. Gallagher's situation, we can see from her case there is a prior history of her working for what was then the Western Health and Social Care Trust in an agency context. She applied for direct employment, and that triggered a fresh obligation for self-declaration on her part and for the obtaining of an enhanced disclosure certificate. When disclosing her convictions, she disclosed that she had been convicted of failing to seatbelt a child while carrying the child in the car in 1996, and she provided further detail on a second occasion in that recruitment process that on the 4th of May 1996 she had carried a child without a seatbelt and been fined £25. When the enhanced disclosure certificate was issued, and I don't ask you to turn it up, but you can see that at MS 8414. In fact, it transpired that Mrs. Gallagher had 6 convictions and not the sole conviction that she had disclosed. She had on the...
What she disclosed was consistent with one conviction.
No, she had only disclosed 1 conviction.
She disclosed the date of the offence
Yes,
and just carrying a child without a seatbelt.
that's correct, yes.
That's consistent.
Well, my Lord, perhaps on one reading of it, yes, one could interpret it in that fashion.
It's not consistent with there being another conviction in 19...
No, indeed, of course. That is a particular feature of her case because, in actual fact, when we look to the multiple convictions situation, one understands entirely that it can be cover a gambit of situations. It can be multiple convictions arising out of the one incident. It can be multiple convictions imposed by a court on the one day, but covering different dates and different offences, different circumstances. Or it can be multiple convictions over a period of different dates, different times over the years. In fact, Mrs. Gallagher's case straddles really all of those circumstances, perhaps surprisingly. And it was, seems to be clear, it seems to be a common case accepted by the respondent, Mrs. Gallagher, at least at this stage of her case, that the trust withdrew the offer of employment, not based on the fact that they had been made aware of the convictions, but on the fact that she had not disclosed the convictions in a fully compliant and clear fashion. So they saw that as a serious breach of trust and clarified that's why the post, the opportunity of the post was withdrawn. So the operative reason for non-employment in this case, we say is incompatible with an argument put forward by the respondent that she lost out on employment as a result of the disclosure on the EDC. For that to be right, one has to really see that as an attack on the entire structure, the entire requirement of disclosure. And really the operative reason in this case was the failings on the part of Mrs. Gallagher herself. The interesting aspect of that for our purposes is that the history of her employment, her training to be involved in that employment, demonstrates that notwithstanding the full convictions having been displayed on enhanced disclosure certificates on some 9 occasions prior to this operative application and subsequently, there's actually no evidence that the disclosures made by Access NI, by the Department of Justice, have had a detrimental effect on her ability to secure employment and training in that field. And it is clear by the time of the first instance decision in this case that Mrs. Gallagher was employed by a housing association providing personal care to adults and had not been held back by her conviction history. If we perhaps look into that in a little bit more detail, we say that that indicates that in the context of a disclosure of information regime such as this, the role of the employer is of key importance. and that the drive on the part of the respondent to suggest that there should be either a more nuanced system of structural rules, or more pointedly, that there should be, in all occasions, an individualised review by the state of the disclosures that will be made, serves to do a disservice to the role of employers in the assessment of risk in employing people in these specialist fields. It's clearly an important role, and the evidence would tend to suggest, particularly from this case, that employers take it seriously and are mindful of the need to manage the information they're provided with in a careful and proportionate fashion. And in order to encourage that approach on the part of employers, the structure of the law is such as to provide for an offence for the improper disclosure of the information provided to the employer outside the requirements of the business need for that disclosure, subject to some exceptions. For example, if it's required to be provided to a government department for safeguarding purposes. And for the court's reference, the construction of that offence is found at page MS 102, section 124 of the 1997 Act. There's also a code of practice in place in Northern Ireland, and the code of practice that was applicable at the time of the Gallagher application can be found at MS 8542. The code of practice, amongst other things, requires that employers have a policy for the employment of ex-offenders. It will not be acceptable that that policy would amount to an automatic non-employment of ex-offenders. Access NI conduct compliance visits with the bodies registered with them under the Act in order to ensure compliance with the code of practice, and particularly in terms of the management of the information that is provided to them. The clear aim of all of this is to assist employers in the proper use and management of this type of information, recognising that it is material that has the potential, at least, to have an unfortunate impact on the individual if it were to be misused and become the subject of tittle-tattle in the tea room, etc. So the purpose is restricted to the persons within the registered body who are involved in the decision about the suitability of the applicant for employment. Now, it's clear in this case, as we've already indicated, that the impact of the disclosure regime on Mrs. Gallagher was really rather limited. And one must guard against the risk of a general overplaying or overemphasis of the risks that may be posed to applicants for employment from the provision of criminal record information to employers. We respectfully say that in this case it is clear that the multiple convictions would have had not just a general relevance, but in actual fact they have potentially specific relevance. Now, this is not to say that Mrs. Gallagher is in some form an arch criminal, Professor Moriarty of the crime world. Plainly she is not. But she does have convictions which on one reading go to demonstrate a recklessness on her part in relation to the management of risk of those in her care. That is, in our submission, something that is entirely within the relative bounds of useful information to an employer in the field in which she was seeking employment.
Back withdrew the offer on a different ground, namely that she had suppressed part of the information.
Yes. Well, can I say in response to that, my Lord, that we know from how the Trust had dealt with this lady previously, when she was an agency worker, and how the agencies that she was dealing with had not held that material to be against her and prevent her from taking up employment in that field. Our point is a slightly different one. Our point is that it's plainly, on any reading of it, material that is relevant for the employer to consider. And the employer considers it, and it would appear in her circumstances, it did not take the view of the previous employers and training organisations, did not take the view that actually it should be held against her to prevent her from working in that field. But one wants to avoid traipsing into hypotheticals, because it can be a zero-sum game. For me, in this case, there can be any range of hypothetical examples come in and deployed against me. But if, for example, the employer, in any particular application made by someone in Mrs. Gallagher's situation, had taken the view that potentially this job would involve driving duties, and that she would be required to drive either children or adults with learning difficulties from A to B, can it feasibly be said that material relating to her past failures, not once, but on 2 separate occasions, giving rise to 6 separate offences where she had failed to both seatbelt herself and, more importantly and more pertinently, children, is a matter that is not relevant, is a matter that should not be known to the employer. So while we say that there is a general application of benefit from the multiple conviction rule, in actual fact, in this case, one can see a specific benefit and one can take a further general benefit from that specific benefit. It illustrates the point that we we say is served by the multiple conviction rule itself. My Lord, Lord Hughes had drawn out with my own friend Sir James Eadie some of the issues about multiple convictions and how on different occasions it might mean different things. I think we probably would have to accept that there might be a different degree or nuance of importance taken from multiple convictions arising out of one incident as opposed to multiple convictions arising out of 2 different incidents several years apart. But it does not entirely dilute the importance of the multiple conviction rule in a general sense, because there is still a resonance from the fact that somebody, even in the one incident, had engaged in criminality of more than one nature, giving rise to more than one offence. We further say, of course, that in a scheme of structure and rules, that trying to separate out the multiple convictions along the lines of was it in one day, was it in separate incidents, becomes extremely difficult and quite a mandrolic and laborious process. It's very difficult to see how it can be done by automation or in any kind of structured, straightforward fashion.
Just help me with something that I'm...
Yes.
Because I'm looking at the Code of Practice, which bears a striking similarity to the one we looked at earlier. Am I right in thinking that, in fact, applications for certificates have to be countersigned by an employer or other body?
Registered, somebody from a registered body.
That is registered?
That's correct.
With it's called Access NI.
For a standard or enhanced certificate, yes.
Yes, not for the basic one, that just goes to the person concerned. Yeah. And that in order to be registered, they have to comply with the Code of Practice.
Yes.
Yeah. And I noticed that the Code of Practice lists the things that the employers should take into account when deciding what use to make of the disclosure. This is under section 4 on page 360 or 8555. They look remarkably like the factors that cropped up in T and in other cases, but they're a little bit more detailed than that. So is it your argument that employers they've got to use the information fairly? We knew that from the English one. They've got to have a written policy on what they're going to do about employing people with a criminal record. And in the individual case, they're supposed to take into account all of these factors.
Well, that's the guidance to them, that they should do so. The aim, of course, on the part of the employer is multifactored. Their primary aim, no doubt, is, if it's an employment context, is to make sure they get the best person for the job. At least one would assume a responsible employer would have that as their ultimate aim. In so doing, they will be required to consider the suitability of that person for the post. And these are the type of factors that it is suggested to them as guidance they may wish to consider in making that suitability assessment, which involves a consideration of risk. And
Well, it goes further than may want to take it into account. Employers should consider the following. So they've got to take it into account.
This is in the context of deciding what use to make of the information that's been disclosed.
yes.
It's not in the overall context of how you go about recruitment. It's very specific.
No, it's specific, and in fact, it's primarily related to the point in time in which they're sitting with the disclosure certificate and interpreting it. Albeit, obviously, they may also have engaged the self-disclosure provisions under the Rehabilitation of Offenders Order route as well, or instead of this. So, in the final analysis, my lady, one might say that it is a matter for the employers. It's not really possible for Access NI, the Department of Justice, to police how the employer makes the decision.
Well, I think that you might say that by reason of these particular provisions, there is a built-in assessment on a personalised basis.
Well, that's the offer to them. That's the one side of it is to have.
I'd accept gifts when you're given them.
Yes,
I'm sorry?
I'd accept gifts when you're given them.
Yeah.
because they might be withdrawn.
I might think of a good reason for
I'll
withdrawing.
move swiftly past that. We respectfully say none of this is particularly controversial, that the employers should have this role, and indeed that most employers will exercise it conscientiously and properly in their own interests and in the interests of those to whom they're, for example, providing services. And could I suggest that it is notable that at MS 4852, there is a quote from Mr. Stacey, who is the director of Unlock, who's one of the interveners in this case, who makes the point that many people with criminal record information do obtain jobs where they have required enhanced disclosures.
Which paragraph is that, please?
It's page 4852, my lord, and
The bottom of paragraph 16.
yes, thank you.
Oh, yes, I see.
And now, in fairness, Mr. Stacey does go on to say over the page that that's not, in his view, a perception that is widely held, and he considers that there is what might describe as a chill factor, therefore, that individuals with conviction material, criminal record material on an EDC might feel inhibited from applying for these posts because they perceive that they will lose out. That, of course, if that's right, that would be perhaps unfortunate. That's a matter perhaps of education and drive forward by employers to make it clear to the wider populace that, in fact, having convictions of this nature will not be an automatic bar. This is not a barring exercise. This is simply an information gathering exercise, an information provision exercise, and employers are ideally placed to make the final decision. They are the ones that perhaps know best what the duties of the post will be, and be able to interpret the risk as they see it from a conviction of a particular nature, that what it might mean for the conducting of those duties. Mr. Sir James talked as well about opening the door for discussion. It's not the closing of a door for an applicant. It provides an opportunity for them to contextualise and explain their conviction, and to work with the potential employer to demonstrate that, in fact, it does not and should not prevent them from taking up the post, if that, in fact, is the employer's assessment of the situation.
I mean,
At the end of the day,
the information provided by the interveners tends to suggest that this ideal is very often no more than an ideal, but it's very frequently honoured in the breach.
well,
And that's the reason why these problems arise. That
yes,
in practice, employers attach more importance to convictions than the convictions in themselves necessarily warrant.
I think probably on an anecdotal or realistic basis, Lord, one has to accept that that can't be ruled out, that some employers will react to it in that fashion.
But, I mean, it's extraordinarily common for employers to take the view that any conviction is objectionable.
Could I respectfully ask the court to approach that concept with some caution? The evidence...
Factually wrong, or because it's not necessarily a relevant fact?
No, because, Lord, I think that for it to be said and for it to be put forward by those who have had a bad experience of that is one thing, but it's not necessarily the entirety of the piece. And for example, and I appreciate it is just but one example, Mrs. Gallagher's case is a key point as an example in the country. So one might say, well, her offending is at the minor end, and I accept that her offending is at the minor end. I've made the point that she's in no way to be seen as some arch criminal, but her offending still has a resonance and a relevance. The employers have demonstrated a clear ability to assess and balance that in a way that has not actually served to detriment her. So for the purposes of this case, I accept that in particular one of the interveners has put forward submissions, evidence that would tend to suggest that this is a problem issue. I don't suggest that it is not a problem at all. What I simply say is that it may be difficult for this court to make anything other than a value judgment about what the extent of that problem actually is. And you consider that in the wider context of two particular factors. One, the scheme as it now currently exists in Northern Ireland, or more correctly, as existed at the time relevant to Mrs. Gallagher's application in 2014, a strong system of filtering that she, and because of the nature of her offending, did not benefit from, but that's the underlying scheme in which it operates. The second factor being the overall importance of the public protection imperative that exists behind all of this. That there will be undoubtedly occasions where some people who would be perfectly acceptable, very good employees will lose out. There will be other occasions, unfortunately, where the management of risk, the balance, will not have been struck in strong enough a fashion, and those who pose a risk will slip through the net, will be appointed, and potentially the consequences can be very severe. This is not a wisdom of Solomon type approach on the part of the Northern Ireland Executive. It is, we say, a fair and reasonable attempt to try to balance out those difficult factors, difficult issues, in a way that provides a semblance of fairness to the individual while at the same time protecting wider society.
Well, another way of putting it might be that even if one proceeds on the premise that there is a well-established phenomenon of employers or potential employers acting defensively and not taking on employees that they might otherwise do, the most that the state can do is to devise a system, general application, make it part of that system that the factors such as you've drawn our attention to in the Code of Practice are brought to the attention of the employers, and to monitor through Access Northern Ireland the adherence of employers to that particular scheme.
In reality, my Lord, yes, we say that's largely where matters stand. Inevitably from that, as I've indicated, there will be some people who end up in what we all collectively or individually might consider to be an unfortunate or harsh situation. But that does not by itself undermine the merits of the scheme and the aims that it seeks to achieve. I probably should say something about the current state of play in Northern Ireland, because it will not have escaped the court's attention that since the regime in place from April 2014, there has been a further series of changes made by the Northern Ireland authorities. And I have perhaps the singular or unique honour of coming before the court as counsel on behalf of an emanation of the Northern Ireland Government, presenting what might be seen to be great progression and step forward. It's not something perhaps always necessarily what comes before this court. So we, as you know, have now a limited review process. That came into play in 2016. Was brought into effect by virtue of the Justice Northern Ireland Act 2015. And the mainstay of it really is found, if I can ask, if you wish to turn to tab 32 in volume 4 of the authorities. You can see the review scheme set out in what is now Schedule 8, capital A.
Can we have the electronic number, please?
Oh, sorry, beg your pardon, Lord. It's MS 1197. So, Schedule 8A to the Police Act 1997 introduces the role and function of the independent reviewer, and the independent reviewer will consider all certificates that display information, criminal, just conviction related material for those under 18, in other words, imposed on those under 18.
Where's that particular provision, please? Which paragraph?
Is it paragraph 4, perhaps?
Yes.
Paragraph 4 and 5, I think.
And there is a further facility by which those who have conviction material, criminal record material, aged over 18 can apply to the independent reviewer for that to be removed.
Yeah, that's 4 and 5.
Mm-hmm. Yes. Now, if we turn back to the core bundle, and page 8141, MS 8141. Paragraph 114 of our printed case, we say the emergence of the independent review marks a limited step of progression in the progress governing the provision of criminal record certificates. Statistics show from the 1st of March 2016 until the 31st of March 2017, 456 cases were reviewed. Most cases, 395, were automatic referrals. So that's material relating to those that was imposed and they were under 18. The remainder were appeals. Information was removed in 364 of those cases.
Does the schedule have a criterion for removal?
No,
I've been reading it very quickly.
Yeah.
I couldn't see an actual...
Actually, the best place to see how the independent reviewer goes about that task is to look to the statutory guidance which is provided for the independent reviewer. That's in volume 13, Lady, at tab 134, 4814.
Provision for the guidance in paragraph 3.
That's right.
Then we're going to find it where?
It's at MS 4814, my Lord.
Thank you very much.
None of this applied, of course, to Mrs. Gallagher.
No, it didn't, my Lord, that's right. That's come to that point, surely that's Mr. Wolf's main point in respect to this aspect of the case. It's all very interesting, but of course it didn't help Mrs. Gallagher. So you can see the statutory guidance sets out various principles to be applied by the independent reviewer when conducting his review. And as a matter of interest to the court, I don't necessarily ask the court to turn it up now, but the first annual report by the independent reviewer for the year 16 to 17 can be found in the same volume at tab 138, MS 4929.
Well, it looks as if the reviewer has to start from the basis. I'm looking at 4817, paragraph 8, principle 1. He's to remove the record only if satisfied that it wouldn't that doing so wouldn't undermine safeguarding.
Yes, it's probably another manifestation of the precautionary approach, my Lord, that the reviewer will have as a starting position. And in fulfilling the role, one of the difficulties that any review process might have is what's the level of information that's going to be available to the reviewer in order to try to better understand and get closer to the real issue of risk and whether there should be a reviewing out of material. That, in this context, is perhaps dual-purposed or twofold, because there will be obviously a provision or an ability on the part of the person themselves to provide information to the reviewer for the purposes of their appeal. But the reviewer also has a statutory power to require the police, the probation board and the Department of Justice itself to provide any information that they might have in relation to the circumstances of the matters that are of relevance to him in considering his role.
Well, notwithstanding the fairly forthright injunction contained in Principle 1 to which my Lord has referred, quite a significant percentage of cases have had the information to some extent removed, which might be an indication of the lack of efficacy of the system before 2017.
Could I put it perhaps slightly differently, to my Lord, put it this way, that the court's already heard today the explanation about the precautionary approach put forward by Mrs. Mason, that the filtering regime would start from a position of caution. certainly from the Northern Ireland perspective, the filtering regime is not something that is cast in stone for all time. I'd say the government in Northern Ireland, the department, probably a better way of putting it in Northern Ireland, is committed to conducting reviews on a timely basis in respect of the structure of the scheme. And realistically, probably what has been shown by the amount of material that has been reviewed out by the reviewer is that in some places where the bright lines have been drawn, perhaps in Northern Ireland could be subject to some finessing or manoeuvrability.
Well, it's not a matter for you, but it might reflect on the proportionality of the scheme for England and Wales, that there is no such system of review.
Well, far be it from me to take on
No,
the
well,
offence of the English position. What I would just simply say about that, Lord, is that our regime is not a carbon copy of the English regime. The lines are drawn slightly differently, and it may be that what's thrown up by the Northern Ireland experience would not be something.
You were telling us earlier that this is a superior scheme. But anyway, we'd probably better not pursue that particular line.
It looks, doesn't it, Mr. Cole, as if from Principle 4, this is a scheme which doesn't only allow applicants to seek a review, but the reviewer is required to give them an opportunity to make representations, and it contemplates in paragraph 30 that he will be asking for information from one or more of the record holders.
Yes.
Because there's a statutory duty on them to comply. So he conducts, obviously on paper, quite a hearing, doesn't he?
Well, it provides the opportunity, my Lord, for that, I think.
Well,
in any one particular case,
he must afford them the opportunity to make representations,
yes,
according to the guidance.
It may be, of course, in any particular case, the independent reviewer would consider, having looked at the papers, that in fact he's satisfied the material can be reviewed out without representations. But I suspect that really the way it would operate in practice is, if he does not reach that preliminary view, then there would be an opportunity for representations before reaching a final view as to whether to review out or not.
This is effectively a scheme which comes close to amalgamating the functions of the discloser and the employer. It doesn't make them synonymous, but essentially the reviewer is carrying out the kind of operation with something like the kind of information that would otherwise have been available only to the employer.
I think inevitably, my Lord, once you bring into play a review structure of this nature, it moves on the continuum of the decision-making. It moves the state's decision-making closer to the type of decision-making that in any other case the employer would be making. Of course, in the final analysis, in any one case, the independent reviewer might not review out some of the information, might not review out all of the information. So there might still be material that goes forward to the employer, and they will then themselves have to conduct an exercise along these lines in making the final decision. Obviously, if the material is entirely reviewed out, then the employer's decision in that regard falls away. With one wrinkle to that, because we don't like to entirely do things straightforwardly in Northern Ireland. And this review process, as your Lordship and Lady will know, only applies in relation to the Police Act aspect and the Police Act pillar. So at current time in Northern Ireland, there is no review mechanism relating to the imposition of a self-disclosure requirement. So if an employer, in the appropriate circumstances, asks in an application form for the person to disclose their convictions, and if it's an exempted question and it's not related simply to spent convictions, then this review process does not really come to the individual's aid. Further limitation on the process is that it does not address itself to the situation of unspent convictions. So the reviewer, his role only kicks in at the point in time in which the conviction is spent. For the sake of completeness, a further movement in the scheme since 2014 is the move away from a reliance on the Northern Ireland criminal justice record management system of Causeway, and instead a reliance upon the Police National Computer in common with the rest of the United Kingdom. The immediate implication of that, for the purposes of Mrs. Gallagher's case and the consideration of Mrs. Gallagher's case, is that if now she was getting an EDC, the convictions which have been disclosed in relation to her as relevant to this case would not be disclosed because they are not recordable offences. And the PNC will ordinarily only disclose recordable offences. So all of this, both these aspects, allow me to learn from Mr. Wolfe to say, well, clearly this indicates that the regime that was in place, operative for Mrs. Gallagher's circumstances, was not good enough. And in fact, I think that's the phrase that he uses at one point in his stated case, that it was not good enough. We respectfully say, of course, that's not the test. The fact that one could have a more nuanced system, that one can introduce some degree of reviewability, does not by itself mean that the scheme that was in place April 2014 is suddenly to be deemed unlawful.
Well, the fact that the scheme could be improved in a variety of effects doesn't mean that the previous scheme is automatically incompatible with convention rights.
And one must guard against the unfortunate shibboleth of no good deed going unpunished. That leads to a defensive policy making, that policy makers such as the Department of Justice and Access NI would say, well, maybe we could see our way to changing bits and pieces of the scheme that we have in place, but we better not, because if we do, we'll only end up in court being criticised for the fact that in the past it was different. Past a foreign country, sometimes they do things differently there. Does not mean that it has the attributes of illegality to be put upon it. Really, my lords, unless there's anything further specifically, those really are my submissions. And as I've indicated at the start, grateful to Sir James. He's covered much of the territory that I would otherwise have wished to cover. And I hope that I have avoided repetition as far as possible. And I should try to avoid that right to the end.
Thank you very much indeed,
Thank you
Mr.
very much.
Cole. Well, now we've got 10 minutes left of today. Do you want to make a start, Mr. Southey?
Quite happy to make a start if it would assist my lady and my lords.
Well, if we could avoid starting early tomorrow morning, that would assist us even more.
Extra hour, we probably could deliberate.
Oh, yes, we might. Yeah, we might.
Oh, sorry. No idea, no, I don't think you do.
Can I start by making, I want to make in fact 5 submissions about the context, but given the time, if I try and explain, identify what they all are at this stage, that will take up all my time. Can I start by making 2 quite important submissions that I think I can do tonight, which will probably put everything else I'm going to say in context. The first is this. It is important, particularly given some of the submissions my learned friend made, Sir James, to remember that this is not a situation where, in one sense, there is a true bright line. And the reason I say that is this. It's important to recognise that this is a scheme that allows flexibility where the interests of the state justify flexibility, but not flexibility where the interests of the individual justify flexibility. To use an example, the filter you've heard a lot about has the potential to filter out convictions because it operates automatically that may be regarded as relevant in particular contexts. If somebody is applying for a particularly sensitive job, some of the convictions may be seen as relevant. Now, the state has an answer to that, and the way that is addressed potentially is by adding those convictions back in as soft intelligence through the enhanced criminal records system. If one looks at section 113B4, which is the provision that allows for what's sometimes called soft intelligence, it essentially allows any record that is held by the police to be put into an enhanced criminal record certificate. And that allows, and this has never been challenged below, that allows convictions that have been filtered out to be added back in. So one sees that there is a flexibility to protect the interests of the state. If someone's applying for, as I say, a particularly sensitive job, the state can say, well, we have a justification for disclosing this conviction. There's no flexibility the other way. And that's why I say it's not a true bright line. There is flexibility, but it's flexibility that only operates in one direction. The second...
Sorry, can I just, are you coming back to that, or can I just...
No, I can just, my lord, for the reference, it's Core Volume 1, tab, or Core Volume Authorities 1, Volume 1 of Authorities, tab 2, page 53, memory stick page 53. It's section 113B that deals with enhanced criminal record certificate. One sees under subsection 3, an enhanced criminal record certificate gives the prescribed details of every relevant matter. Relevant matter essentially is the criminal convictions, and any information provided in accordance with subsection 4. And subsection 4 essentially provides for, one sees it further down the page, for the DBS to request information which the chief officer reasonably believes to be relevant and believes ought to be included in the certificate. So if one has a conviction that has been filtered out, but the chief officer believes it is relevant, one can add it back in.
Well, that would be subject to any limitations that might be inferred from the scheme in general.
Well,
not sure it goes without saying that submission is correct.
Well, except if what section, what the if one looks at the scheme as a whole, quite clearly the enhanced criminal record certificate is intended to give effectively a flexibility to the police to ensure that material that is identified as being relevant, and it needs to be material where disclosure is proportionate, is provided to an employer. Now, if one had a situation where, say, the filter had operated in the way it's intended to, but had removed material which the state legitimately had an interest in providing to an employer, in our submission, there's no reason why it can't be provided under the enhanced criminal records certificate. I mean, to use an example...
The object of this scheme is to comply, inter alia, with Article 8 of the Convention.
Absolutely.
It excludes certain information whose disclosure is regarded as in principle unjustifiable. I think it's at least questionable whether that information can be reinserted under a different and more general provision.
Well, my Lord, if the state has I accept the state would have to start from the position that this is material that is generally regarded...
You say the state, this is the chief...
Sorry, this is the Secretary of State. Well, yes, the chief officer makes the decision.
Yes, he makes the decision it's relevant, and it's then subject to review, isn't it?
It's potentially subject to review under that process.
So,
There's some guidance about this, isn't there, Mr. Southey? Does it say anything about adding back convictions which are otherwise out?
I need to double check, but I'm not sure. As I say, it's certainly below, from my memory of the way in which the case is argued, this is not. And indeed, the Court of Appeal expressly, there is a passage in the Court of Appeal's judgment which expressly says that is a way of doing it. And the reason I say that, in any event, is in some senses that links into our arguments about the potential relevance of the sex offender system. If one were to have, if you like, a system where one could wipe clean for general purposes one's conviction, that doesn't mean that you couldn't also have a system where on an individual basis it needed to be added, it could be added back in if there was a particular justification.
Most sex offences are disclosable anyway under 13A.
Just about everything.
By virtue of the nature of the offence.
My Lord, sorry, I was using shorthand there and I probably wasn't explaining well the point I was making. The point I was making was the way the sex offender scheme operates since F is that an individual can go forward to, in fact, again, a police officer, but with the right of appeal, and say, this scheme should no longer apply in my case. Because I'm low risk. All I'm saying was it's easy to conceive of a system where you could come forward and say, because of the passage of time, because of the trivial nature of the offences, I should no longer be subject to this system of effectively automatic disclosure. But if you were to get a ruling of that nature, there's no reason why, in principle, it couldn't then allow for individualised decisions should that be necessary in particular circumstances. I mean, it deals with, there was a striking, the reason I make that point is that there was a striking point in Malone and Friends submissions this morning where Malone and Friends said you have to take account of the fact that under this system, because there are a large number of employers who may need certificates, information may need to be disclosed to a school, which is, for example, irrelevant to the school, but is relevant to financial services providers. Now, that it suggests that there is the potential for quite a large amount of information to be provided that's irrelevant, because you're trying to disclose material to a wide range of employers who will have different needs. What I'm suggesting is that within this system there is already the capacity essentially to deal with specific needs, and one way of doing that, and one way that you could sort of expand that essentially, is by having a system which allows you to apply to come off the system, but allows material to be added in for specific purposes.
Isn't there somewhere a separate collection of particularly sensitive jobs to
Yes.
which different rules apply?
Yes.
If you want to go work for MI5, or indeed, I suspect, become a judge, you may find that there are rather different rules about.
Yes, there are. There are. In particular, in the order, my Lord will see that there are. We've been talking about these sort of bright line rules.
Given that, I just wonder whether it's sustainable to suggest that people could, put it crudely, get away with adding back in convictions which are otherwise excluded.
Well, my Lord, except the problem is one can see that what may be relevant to a school, for example, may be very different to, and both have, both are not in one sense particularly sensitive. They're not the MI5 situation where a very wide range of offences is potentially relevant because of the potential for blackmail, but the information required by school is likely to be very different to the information required by financial services providers.
This is such an elaborately calibrated system with its exceptions and exceptions from exceptions and so on, that I find it very difficult to accept that you can simply drive a coach and horses through the whole thing by a police officer deciding that, well, it ought to be thrown in anyway.
But, my Lord, the answer to that is, of course, it is subject to control, because if it goes through the enhanced criminal record certificate, there is the potential for independent review. If the independent review it produces a flawed decision, there is the potential for judicial review. They're relatively rare since the independent review, but in principle, one can judicially review the independent reviewer. So, my Lord, there are safeguards to make sure that it is properly Article 8 compliant. The difference is that in those circumstances, one will have looked at the individual circumstances, one will have looked at whether or not the particular employer needs this information, one will look at whether or not it actually demonstrates risk, whether it demonstrates relevant risk, all those sorts of factors, and will have come up with a decision that actually is...
When the Chief Constable is asked for, under 113B4, whether he wants to chip anything into the ECRC,
yes.
Is he told what the application is for?
Well, I'm not sure that we
Not
have the.
4 years.
Well, he will know. He will know for a start who the employer is, and the employer will have had to apply
Because they'll be registered.
because they'll be registered. So it won't be. It won't be. They won't be without. One would assume they're not without any information because they will have registered and they will have
Won't
indicated.
necessarily know what work it is.
Sorry.
Won't necessarily know what job it is, will he?
Won't necessarily know what job it is, but of course, when one looks at L, my lord, L suggests that if there's uncertainty, the police officer should ask for that information.
All right.
And
And it is relevant that under 113B2, the application not only has to be countersigned by a registered person, but must be accompanied by a statement that the certificate is required for a prescribed purpose.
Yes, but
yes.
Which presumably would convey, in most cases, information about the employment.
My lord, can I just, it may be that I need to come back tomorrow morning on this, but I've just been handed by my learned junior the guidance, and the guidance does expressly say, my lord, Lord Hughes had a better memory than me, that in fact filtered out convictions can be added back in through the enhanced criminal record check system. I'll give.
Can you give me a page reference for that?
Well, can we produce the page reference overnight? But
Well, that seems to be you've not got very far with your two propositions. You've been challenged on your very first one. Anyway, the plan is to start at 10 o'clock tomorrow. It would be even though we've now saved an hour by Mr. Cole's economy, in fact more than an hour, it would probably suit us if it were still convenient for all of you to start at 10 o'clock tomorrow morning, and then as much time as possible can be saved on Thursday, if that's all right by everybody. Good? Well, the court will now adjourn.